My name is Ed Cracknell and I'm a partner in the property and housing litigation team here at Russell-Cooke. I'm going to be answering a few quick fire questions that might be asked by homeowners, and I'm going to try and do it in a couple of minutes to try and maintain your attention. So, first question. My neighbour's fence blew into my garden and caused some damage to my plant pots. What can I do? Well, the first thing is to check your property deeds. It may be in fact that the obligation is on you to maintain the fences. If not, and if you're certain that the fence belongs to the neighbour, then ask them to repair the fence and to pay for the damage. If they decline, well, you probably can't force them to repair their fence. You might have to put your own fence up on your side of the boundary, but why not try offering to pay, say, half of the cost in order to maintain the neighbourly relationship. Question 2. I need to access my neighbour's property to carry out repairs to my side wall, but they are refusing. Well, the Access to Neighbouring Land Act entitles landowners to apply to court seeking an order for access to neighbouring land to carry out essential repairs to property. If successful in obtaining such an order, you may have to pay compensation to the neighbour for loss of privacy or inconvenience suffered by them. Proceedings are generally expensive anyway, so you should consider exhausting all efforts to get them to voluntarily provide access, including an offer of financial compensation. Next question. I recently bought a house and the seller did not disclose a long-running dispute with the neighbours, who are horrible. Can I give the property back? Well, you may have heard of the phrase buyer beware, which means that sellers are under no duty to provide any information about a property on a property sale. But what does tend to happen in the conveyancing process is that sellers will answer a series of questions in a property information form, one of which asks about disputes. So if the seller said that there had been no disputes, but you can prove that there have, then you may have a claim, either to reverse the sale or for damages. Now, you will need to show that you relied upon their false representation in purchasing the property, and you'll need to show that you've suffered a financial loss. You must act quickly, and it's important not to make any changes to the property so that you then wouldn't be able to give back what you purchased. Next question. My neighbour says that my garden fence is in the wrong place by a few inches, but it has been there for around 15 years. Do I need to move the fence? Well, there's an area of law known as adverse possession, which entitles people who have occupied land for a long period of time to claim that land as their own in certain circumstances. So in this situation, assuming the land is registered, you can, if you can show that the fence has been in place for the last 10 years, you can apply to the land registry to have the land registered in your name. Now, you will need to show that you reasonably believed you owned the land. In other words, you reasonably believed that the fence was in the right place for that period of 10 years. If that applies, the land registry will ask the neighbour whether they object, and if they do object, it will go to a tribunal. Now, if you are unsuccessful at the tribunal, the neighbour will have 2 years to evict you from the land. And if they fail to do that within those 2 years, you can apply back to the land registry, and this time they will definitely order the land to be transferred into your name. So that's just about it. If you do have any questions about property law or property disputes, do feel free to get in touch with me or another member of the team.